apologize for the delay, and we will now start the meeting. So our scheduled business today will start by voting on the draft July 2019 board meeting minutes, which board members have received and are posted on the board's website. Will a board member move for a vote to approve the minutes? Second? Any edits or questions or debate?
I have one edit. One edit, Chair, and the discussion of, I believe it was the discussion of the serious injuries. The last sentence, I'm referenced as saying that it's very important for the board to investigate all serious injuries, but that's not the board's responsibility. That's the department's responsibility. But it's very important for the department to investigate all serious injuries. So I'd like to ask that be changed. Board is interested, but it's not what I meant to say.
Can I have a motion to amend the minutes as indicated by Dr. Cohn?
So,
Second? Thank you. Do I need, all in favor? The minutes are amended and as amended are approved. We have a few updates before we turn to today's agenda items. First, I'd like to introduce our acting executive director, Michelle Ovesey. Michelle has been the board's general counsel since 2015 and continues in that role as well. Prior to joining the board, Michelle was general counsel and then commissioner of the New York City Department of Homeless Services. The board is grateful to Michelle for stepping into this role. She already has provided the board's exceptional staff with strong leadership, and we're confident that she will continue to do so as we undertake a national search for the board's next executive director. On August 21st, the board publicly posted the job description for executive director on its website. We seek an accomplished leader with a demonstrated commitment to criminal justice to play a significant role in efforts to reform the city's correctional system at a time of unprecedented visibility and urgency. Please see the job description for details on how to apply. I have one scheduling update. The board has moved its October public meeting to Tuesday, October 22nd, 2019. The meeting will start at 9 a.m. in this room at 125 Worth Street. I'll now ask Michelle to provide a few updates.
Thank you. I have 3 updates. The board has recently published 2 reports on its website. Yesterday, we published our final report and recommendations on jail conditions and operations during the July 2019 heat emergency. This report is a follow-up to our July 22nd preliminary findings and recommends improvements in 4 key areas: daily temperature monitoring, heat-sensitive people in custody, restrictive housing areas such as punitive segregation and enhanced supervision housing, and short and long-term action to mitigate heat risks. Our ultimate conclusion, however, is that the problem is one of infrastructure. There is simply a lack of capacity to ensure humane conditions for all people in custody and all people who work in the jails during hot weather. The report recommends the city intensify its already impressive efforts to decrease the jail population while exploring capital spending now to expand air conditioning in the jails. We thank the Department and Correctional Health Services for their dedicated efforts during the heat emergency and their responsiveness to the board's questions and concerns. The department submitted a response to the board's final report, which is also posted on our website. Many thanks go to board staff Bennett Stein, Emily Turner, Cherie Tripp, Katrina Blackman, and Kristen Harris for assisting in this important effort. The second report is an update. Oh, sure. The second report is an update on 60-day punitive segregation overrides, and 60-day sentences. Since the 2015 amendments to the board's minimum standards, the number of 60-day overrides requested and approved has decreased substantially. From fiscal year 2016 to fiscal year 2019, the number of overrides requested declined by 80%, from 168 to 34 requests. In the last year, fiscal year 2018 to fiscal year 2019, there was a 53% decrease from 72 to 34 requests. And in the first quarter of 2019, the department approved only 2 override requests, the lowest number since it started using overrides. Finally, the board is convening a task force on issues facing transgender, gender nonconforming, non-binary, and/or intersex people in the jails. We are honored and we are very excited that the City Council has selected the board to lead this important effort. The task force will include government and community representatives. Board staff has done significant outreach work already, and we are accepting task force member nominations from the community until September 15. More details on how to apply are available on our website.
And I'd like to give a brief update on the board's restrictive housing rulemaking. Throughout the summer, board staff have worked tirelessly and engaged in productive conversations with DOC and CHS. The rulemaking committee of the board also convened several times to discuss drafts of the rule. While the board was not in a position to publish the proposed rules prior to this public meeting, we anticipate that we will publish draft proposed rules prior to the board's October meeting. As a reminder, the initial vote anticipated at the October meeting will start the city's administrative rulemaking process, or CAPA, which will include a comment period and a hearing on the proposed rules. The public will have a full opportunity to submit written comments on the proposed rules and testify about them at a public hearing. Following the comment period and hearing, the board will vote on final rules. And before we move into the agenda for today, Commissioner Brand has requested an opportunity to address the board. Commissioner, good morning.
Good morning. Before I start my formal remarks, I'd just like to thank you, Michelle, for highlighting that data on our punitive segregation reform. I think it highlights the fact that, plus what I'm about to speak on, shows everyone that we are not the same agency we were 5 years ago. And we have made considerable strides in our practices and our policies, and we are working hard to get better every single day. So with that, I will say it is with great pleasure that I address the board this morning to share exciting news about a significant accomplishment of the department and to commend the excellent work of my staff. The department has achieved PREA compliance after passing an official compliance audit of the Rose M. Singer Center conducted by a Department of Justice certified PREA auditor. This is the first time a DOC facility has passed an audit and achieved PREA compliance. As the board is aware, a PREA audit is a very complex and comprehensive process that assesses a facility's overall compliance with written policies and procedures, both in their implementation and in the knowledge of the day-to-day practices of staff. I am proud to say that Rose M. Singer not only passed their audit, but the auditor determined that DOC exceeded standards in 4 critical areas. The first, in ensuring individuals with disabilities or limited English proficiency have equal access to PREA-related materials and initiatives. Second, educating all detained persons about their right to be free from sexual abuse in the department's zero-tolerance policy. Third, providing multiple safe avenues for the reporting of sexual abuse. And finally, investigating all incidents of sexual abuse thoroughly, promptly, and objectively. Rosie's successful audit is a direct reflection of the commitment this department has made to meaningful and sustained sexual safety in all of our jails. As Commissioner, the safety and security of those in the department's custody and of those who work in the department facilities are my primary concern, and I take sexual safety standards personally and seriously. I am extremely proud of the work that my staff, both in regards to passing this audit and in their day-to-day commitment to sexual safety, have begun within our facilities. In his report, the auditor repeatedly highlighted the knowledge and dedication of Rose M. Singer's staff and the facility warden in particular, as well as the good work of the PREA Investigations Division team. Achieving PREA compliance has been a long-standing goal of this department. Since late 2014, the department has been working with the Moss Group, a highly respected national leader in PREA compliance consulting, in order to improve sexual safety across all DOC facilities. The partnership between the Moss Group and DOC has rested on an alignment of executive leadership values and comprehensive and well-planned implementation of strengthened policy and practice, leadership and supervisory development, and transformative and skill-based training. Over the past 4 years, the department worked very hard to come into PREA compliance in all of our facilities. Important initiatives have included the creation and full staffing of a PREA investigation and compliance team within the Investigations Division, implementing a comprehensive PREA policy that focused on inmate safety, delivering initial and refresher PREA training to all uniform, non-uniform, volunteer, and provider staff, providing all individuals in our custody with internal and external confidential methods of reporting sexual abuse allegations, and implementing unannounced rounds of housing areas by facility leadership in order to identify and prevent sexual abuse and sexual harassment. The department remains committed to preventing sexual abuse through proper risk assessment and through the provision of safe housing. Every individual who comes into our custody goes through an intake process that includes a sexual safety risk assessment. Further, in accordance with Executive Order 16, the department is committed to housing individuals in our custody by gender identity and created a first-of-its-kind transgender housing model. As noted in the PREA audit, the department has expanded this model to include individuals who are intersex and individuals who are gender non-binary in this housing unit. As a result, the name of this unit has been amended, but there will be no substantive changes to the operation of the unit or the services that are offered. Regardless of the housing assignment within the Rose M. Singer Center, transgender, intersex, non-binary individuals have access to the same programs, education, and health care as anyone else housed in that facility. Transgender female, intersex, and non-binary individuals can also elect to be housed in male facilities as long as it poses no security threat. The success of the PREA audit joins an ongoing list of PREA-related successes which includes a 24% decrease in the total number of sexual abuse and sexual harassment allegations in the last 6 months, and the department's ongoing success in meeting all of the metrics on the board's PREA dashboard. These achievements are a testament of the consistent messaging and application of the PREA standards within the department. I am confident that these efforts will be reflected in similarly successful audits of other DOC facilities as we move forward with our mission to achieve department-wide PREA compliance. I want to commend the hard work of everyone at the Rose M. Singer Center, and in particular Warden Suarez, who has done an amazing job leading her team through this audit. I would also like to thank Deputy Commissioner Serena Townsend, Assistant Commissioner Faye Yalardi, Senior Correctional Administrator Prichelle Shannon for their leadership in their efforts, as well as the PREA and ID units and the leadership of this agency for their ongoing commitment to sexual safety within our facilities. We will be sending the chair and legal counsel an email that contains the PREA audit for distribution to the rest of the board members. And so I just want to thank you once again for the opportunity to share this good news with you today.
Thank you very much, Commissioner, and thank you for sharing this good news. Congratulations to you and to all of your staff on this considerable achievement. And now we're going to move into the agenda items for today. And as you know, we had a variance request submitted by the department in August, last month, dated August 20th, on the agenda for today. And the board has considered the variance and proposed conditions. The department has expressed concerns with some of the conditions proposed by the board, and we've been unable to resolve those concerns as of today. Accordingly, the department has advised that they are withdrawing the variance request. The department will continue to issue emergency declarations and advise the board of placements in separation status and related information, which the board will continue to post on our website. We look forward to continuing our discussion with the department, and we will hear from the public now regarding the variance as we were scheduled. So now I will call on the folks who've signed up to provide public comment on the variance and ask that you limit your comments at this time to the topic of the variance request. There will be, as there always is, additional opportunity to provide public comment later on in the meeting. So first, I call on Mark Steyer.
Good morning. Good morning.
Good morning.
And happy September 10th. And good morning. Welcome, Ms. Ovesi, to a tough job I'm sure you'll do beautifully in. But I'd like to remind the board of something, and I also direct this to counsel for the DOC. Since 1984, the board has been an advisory body, not a judicial body, not a tribunal. And constantly I'm reminded that the board is interfering with the safety and security of inmates and workers alike in micromanaging things that are simply not in their wheelhouse. So I commend you for such interest in the matter. I know Her Honor takes specific concern with some populations as well as Dr. Cohen, and that's commendable, but there are some differences of opinion. So I'd like you all to just know that this case is still good law. And since the issue came up, strip searching is dehumanizing, humiliating, and in 2012, LA County looked to New York, and the fact that we had body scanners, which were then taken out of commission, even though every lawsuit that was brought on behalf of inmates, detainees, was kicked out of court. So again, this is unnecessarily churning things into political matters and legal matters that shouldn't have to go there. And finally, in July of this year, and I'll just read it into the record, Judge Ruben Franco ruled on a case that COBA had filed in 2016 on a motion for the case to be dismissed about the workplace violence law that we have in New York State for public employees. The city has not shown that the DOC has implemented the controls mandated by the workplace violence law or conducted risk assessments for incidents of violence or diffused areas of concern by taking mitigating steps, such as considering the propensities of a part of the jail population, as well as properly training and equipping correction officers to address some of these problems. And as it turns out, on pages 4 and 5 of today's Daily News, you can read for yourself whatever it is that the people then in charge were doing. I am not trying to cast a shadow on the current commissioner nor anyone who's involved currently, but this has to be looked at hard. And this board may want to look at that law. And I thank you very much. Again, I welcome you. Any questions that you may have?
Thank you.
Thank you very much.
Frederick Fusco? Is Elias? Dean? I'll work on it.
Good morning, everybody.
Good morning.
In the last 3.5 years that I've been president of this union, one of the concerns, the main concern of the union at these meetings, at these board meetings, have been safety. It's been the issue of safety. We contend that there is no conversation about anything else if safety is not addressed first. We, the union, COBA, we fought hard to get these scanners into these jails. The agency fought just as hard. You actually supported, publicly supported us getting these scanners. City Council supported. Now we have the scanners. And it's very important that, and I don't want to paint with a broad brush, but it's very important that we don't allow advocates, regardless of what their intentions are, to take away from the fact that since we started using these scanners, that we've been successful in finding weapons. Inmates have been turning in weapons when they look at the scanner, not to even go through it. So we've been being very successful with this thing, and it's important that we don't allow anybody to take the situation of taking an inmate that we know have a weapon, regardless of whether they swallowed it, whether it's in their rectum or wherever it is, and we decide, oh, we have to put this inmate in isolation, that we don't have the advocates trying to equivalate putting an inmate in isolation until we get this weapon with punitive segregation or solitary confinement, because nothing could be further from the truth. So it's very important. I know you said we're going to take this up next month and we'll be here, but it's very important that we understand that safety is the #1 priority of this agency, and it's the #1 priority of this union. And we hope that you continue to stand fast in your support of us getting the scanners and us using the necessary tools such as isolation in order to get these weapons from these inmates. And that's for the protection not only of correctional officers, but that's for the protection of civilians who work in these facilities, the people who work for you inside these facilities, as well as for the protection of inmates. So all I'm saying is let's not allow anybody to cloud the water, to cloud our decision as to what this is about. And getting these scanners was an uphill battle for this union and for this agency, and we expect to be able to continue to use it to make the jail safer. Thank you.
Thank you.
Good? Okay.
Jennifer Parrish?
Good morning. Good morning. My name is Jennifer Parrish. I work at the Urban Justice Center Mental Health Project. I find it deeply troubling today that the board was considering allowing the department to keep some people in 24-hour lockdown, expanding the use of solitary confinement in the jails, and not starting the process for restrictive housing rulemaking. The board is well aware of the harm that solitary confinement causes to people both while they're in solitary confinement and once released. And you've been drafting these rules for an extensive period of time, yet you feel no urgency to move forward with that. Instead, what's prioritized is the department's request to deprive incarcerated individuals of their freedom. The broad exemptions from numerous minimum standards that the department requests are unconscionable. Separation housing status is not designed to be the least restrictive method for accomplishing the goal of recovering dangerous contraband. Instead, the department proposes to isolate incarcerated individuals in conditions that fall far below what the board has determined to be the minimum standards for incarceration. The department seeks to deny all access to the courts and recreation and impose numerous other restrictions without crafting any alternative method for providing these basic services, without the approval of the chief of department or other supervisory staff, and without any limits on the duration of placement in this status. The department's extreme restrictions are not limited to those suspected of having bladed weapons, but include individuals who are suspected of possessing drug contraband. Obviously, the department wants to eliminate the flow of drugs in facilities, but drugs do not represent the level of danger that weapons do. Possession of drugs is not penalized in the way that violent conduct is, and retrieving contraband, such contraband should not trump the rights of incarcerated individuals to the basic minimum standards of humane treatment in jail. Even for those suspected of having bladed weapon, the department proposes depriving them of all access to the courts. The purpose of having them incarcerated is so that they can attend the court proceedings. The department has a range of security measures, including physical restraints and escorts by captains, that they use for transporting individuals that have engaged in the most extreme behavior. Yet they want to deprive individuals in this status of access to courts entirely. The department proposes denying them of access to recreation, even though people in punitive segregation are allowed this, and even those who's been convicted of misconduct related to recreation, there are limits on how long their access to recreation can be denied. They propose denying access to counsel, even when they have the video technology to be able to allow attorney visits that way. They want to deny individuals in these separation status housing of access to ways to clean their cell, but make no other provisions for the department to make sure that that happens. They want to limit all contact with the outside world where they could tailor those restrictions. For example, rather than eliminating outgoing correspondence entirely, they could request permission to open and inspect letters before mailing them. Furthermore, there are no due process protections, no provision for reviewing the scan results by experts to ensure the accuracy of their finding, no provision for the chief of department to review and sign off on placement in this status, no requirement that subsequent scans be offered every 2 hours, no provisions for exceptions for those based on legitimate medical concerns, no provision for how individuals placed in these units who were in mental observation cells previously, nothing specific for people with disabilities of all kinds, young adults, or pregnant women. And finally, the lack of transparency in this process is of great concern. The department's been allowed to use these scanners since January 1st. They talk about the discussions they had with stakeholders and with the board before they began using them in July. So they had plenty of opportunity to ask you to do rulemaking around the status, but they didn't. Instead, they began implementing them, and now they're going to continue implementing them, withdrawing their variants, but continuing the practice. The board should find them non-compliant with these standards. Thank you.
Thank you. Charles Fenimore.
Good morning. My name is Charles Fenimore, and I'm a member of the Campaign for Alternatives to Isolated Confinement. The proposed variance creates a set of offenses for people who are being held to assure their appearance at trial. These new offenses are do not result, the set of new proposed offenses do not result in criminal charges and adjudication before punishment, but lead directly to extreme isolation and other forms of punishment. The Campaign for Alternatives to Isolated Confinement strongly favors the use of humane alternatives to the current and now proposed heightened punitive measures for people in the system in the New York City jails. Isolation is inhumane. According to the United Nations rapporteur, uninterrupted isolation amounts to torture beyond the first 23 hours, and a system that has no breaks from isolation, therefore, constitutes torture. In its effects, it aggravates the condition of those who already have mental health issues when they enter our jails, and it can create mental illness in otherwise healthy individuals. The board should reject the use of all forms of torture in our jails, especially its heightened use represented by the proposed variants. Thank you.
Thank you. Kayla Simpson.
Good morning, everyone. My name is Kayla Simpson. I am a staff attorney at the Legal Aid Society's Prisoners' Rights Project. Thank you so much for giving me the opportunity to address you. And many of my comments have already been said by Ms. Parrish, Mr. Fenimore, so I thank them for that, for not forcing me to repeat them. I want to first emphasize that unlike what we heard a little bit earlier, the board is not an advisory body, it's an oversight body. It is authorized by the city charter to perform that function. It is a critical function, and that is why I am extremely alarmed that the department is withdrawing its variance and thereby completely circumventing this body's ability to impose conditions and protections around this practice. There is an extreme lack of transparency in this process. My office has requested the directives, the operations orders, so that we may provide comprehensive comments. But what we have heard from incarcerated people, what we have seen published in public reports, and from the department's own now withdrawn variance request, raises serious concerns for us. And Ms. Parrish definitely outlined many of them. But I want to be clear about something. You can call this separation status. It is literally solitary confinement. It is 24 hours a day in a cell, no access to recreation, worse conditions than punitive segregation, and with less protections. It is unacceptable for this practice to continue unregulated and without conditions from the board. What do we know about it? We know it's in GRVC Building 2, which was, guess what, used for punitive segregation. We have heard reports from people that no matter what the variance request suggests, that they were denied access to phones and showers. Some were even missing meals. But even just looking at the department's request reveals that even though they say this is not intended to be a punitive measure, that it's intended for the limited purpose of security, that it's supposed to be the least restrictive form possible, a common sense look at it indicates that that is not true. They say that they can provide bedding, clearly, because they don't request a variance request from that minimum standard. But they also say they can't provide a newspaper or a paperback. We don't hear any indication that they are having people screened for mental health or medical risk. That is unconscionable, given the recent deaths in custody. There's no time limit for how long someone can be there. There's no ability for someone to challenge their placement there. There should be an emergency procedure with independent review because the stakes are high. This is extreme isolation. It's severe deprivation. We are asking the board to issue a notice of violation. It is unacceptable for this practice to continue just through an emergency variance mechanism. That's not the purpose of that provision. This is an end run around the process of the minimum standards and the variance process. Thank you so much.
Yep. Yes or no? Yes. Thank you so much for submitting the letter from Legal Aid. I did have an opportunity to review it. We've heard today concerns about due process. What type of due process would you recommend be in place for something like the isolation necessary after scanning, which reveals a weapons contained within the body of the person in custody?
Thank you for that question, Your Honor. And obviously, it's something that we would like to speak with you about in more detail. I can say generally, of course, I want to emphasize as well, we don't want weapons in facilities either. These are our clients that we're talking about, so we have an interest too in safety. I'm not suggesting that weapons be permitted to flow unfettered through the department, right? But your question strikes at the heart of what our concern is that there should be an opportunity for someone to petition, say, the board or someone else, to challenge the placement in this isolation status. And the reason for that is a common sense one. I've spoken to a client, for example, who was placed in isolation after a quote-unquote positive scan. He repeatedly asked for a new scan for 48 hours. He was denied by every captain that he spoke with. He finally got one 48 hours later, and guess what? It was negative, and no contraband was recovered. That is extremely concerning. He needs to have a mechanism to be able to reach out to someone like the board or another oversight body for a review of the decision to place him there. And in the instance when someone is in separation for a longer period of time than a couple of days, and I'm not suggesting that that's okay, but if there continue to be positive scans, certainly there needs to be a process to deal with that. But it can't just be an unlimited time that someone remains in this black hole. There needs to be a hearing. There needs to be some sort of process by which the information that is being used to place the person in this solitary confinement is reviewed. It can't just be this unregulated practice. I think that's really our point. But I'm happy to, of course, speak with you more.
Thank you.
Thank you very much.
Thank you. Kelsey Davila.
Hi, good morning. My name is Kelsey Diavila. I'm the Jail Services Project Director at Brooklyn Defender Services. BDS is alarmed by the department's most recent attempt to impose a form of extreme isolation through the newly minted separation status. And 100% I echo the comments of our colleagues at UJC and Legal Aid. Separation status is a coercive tactic that undermines the order and threatens the health and well-being of people in the department's custody. Essentially, the department is no longer asking, but actually doing, is skirting all rules and to hold people indefinitely without any access to the outside world or basic human necessities. The far-reaching impact of separation status is troublesome. The department is seeking to isolate people for an unlimited period in conditions more extreme than isolation, which the board has already denounced. And no one is exempt. This extreme punishment can apparently be imposed without any consultation with or screening by medical or mental health staff, and without any precautionary steps for young people who have been excluded from punitive segregation. The department must not be able to prioritize its administrative management over people's basic rights. Any person subjected to security status must be provided a medical screening and ongoing treatment to mitigate the risks to their long-term well-being. Anyone on security status must be able to access their counsel and courts even when the department believes they must be isolated in their housing area. The department has long managed to reduce people to court and counsel visits even if they purportedly pose a security threat. This is no different. The security status should not be used as a barrier to accessing counsel in the courts. The department's separation status practice presumes guilt. By imposing the punishment if a person refuses a scan, the department ignores any other reason a person may not want to be subjected to a scan, including health concerns and mental illness. Further, the entire practice completely discounts the possibility of technical failures. Nearly 2 months after the first person in DOC custody had been separated from all human contact under the separation status order, DOC's policies and practices around the newest purported security measure are still shrouded in secrecy. The department has not made available separation status directives, trainings, or other critical practice guidelines. Over the years, the department has imposed a range of restrictive measures on large groups of people in the name of security. Each time the board or the city pushes back, the department comes up with a new plan that's supposedly necessary in the name of security. Whenever given the opportunity, the department expands those plans, and we urge the board to denounce this practice. Thank you.
Thank you. Ms. V? Winston Huen. I'm sorry. Thank you, Ms. V.
Good morning, Board. My name is Minister Victoria Dr. Phillips, and everyone calls me Ms. V. I have been a member of the Jails Action Coalition since 2012 while working on Rikers and seeing barbaric behavior. Around the new separation status that opened in July, I have great concerns. I recently raised my concerns this past Friday at the advisory board, which I've been a member for the last 5 years for DOC. The language that DOC used as they explained these units was, and I quote, "Inmates put themselves there." We all have heard DOC refer to use of these mags as simply going through TSA to board a plane. Yet this is simply not true. As a brain surgery survivor, I asked DOC, what about individuals like me who fly yet opt out of using the mags? I am thoroughly patted down, and although at times TSA might behave as if opting out is annoying to them, they know it's my legal right to do so without having to disclose any of my medical concerns. I asked if they inform individuals of that option, and they all looked to each other for answers. It was clear that if there is a protocol, it's not well known, and my question is, how soon is an individual taken to medical? Because DOC told me that the person will be taken to medical staff to be reviewed. So I want to know, how soon is it, and is it written down so that DOC has no wiggle room to get out of that protocol? Also, we ended solitary confinement for 16 to 21-year-olds in 2014, and then you allowed DOC to open ESH, which is another form of solitary, in 2015. Yet now we hear this separation unit, which is still solitary confinement. And DOC was very clear to say it's not punitive. However, they transport people in full restraints. To me, that sounds like solitary and punitive. I am very concerned about people who might be in these situations, put in these units, and might have swallowed a drug or a baggie or something, because I asked DOC, are they assessed by medical staff, and are they assessed by mental health staff? And if someone did have drugs in their system and they're put into isolation, are they forced to then die because they're in a unit alone? And DOC says that they put people on one-to-one, but all data shows that DOC does not properly staff their units when they're supposed to be staffed. So even telling us that they put people on one-to-one, I have very big concerns about. And it's up to you, the board, to hold them accountable. People's lives are on the line, and we're talking about people who have not been convicted of their alleged crimes, who are facing their day in court and should not have to be brutalized and put into units left unseen and unheard. Do your job, please. Have a blessed day.
Thank you. Winston Huen.
Good morning. I just want to share a brief story. So I was at OBCC from January until May this year, and I had friends come to visit me on March 31st. It was a Sunday. And they told me when they were going through the visit process, getting cleared and scanned and everything, that they, you know how you get your hands swabbed? They said everyone in front of them who got their hands swabbed was coming up positive, and they were being all afforded booth visits because they had drug residue on their hands. And after so many people were coming up positive, and women are crying, they won't be able to see their husbands, someone suggested that the CO doing the test swab her own hand, which also came up positive. And then they realized the machine was giving false positives. Is that situation possible here? I mean, radiologists misread things, right? People are told they have cancer without actually having cancer. I don't know that any of the COs are offered the same type of training, but it's the same basic type of technology, right? So if there's a smudge, if there's a misread, somehow maybe someone was moving, is there that chance for a second opinion, a second scan? Maybe the machine might not be working. I don't know what type of training the people running it may have, what type of maintenance the machines may have, and how regularly that may be. And then my other question was, I know usually when I've seen variances like this before, or for other punitive housing units, tablets are always provided. I think in every other situation, instead of having access to the law library, tablets have always been put in as, I mean, it's not as good, but I'm just wondering why here that situation is different. In every other punitive housing arrangement I've read, the tablets have been provided. And then my last question is, this is a variance, or this was a variance being asked for 6 months. What happens after 6 months? Do we just ask for it again? Or is there a solution for this after the 6 months? Or is this just an ongoing process? Those are my questions. I don't need the rest of the minute, but thank you.
Thank you. Harvey Murphy.
How you guys doing?
Good morning.
It's an honor to be up here. My name is Harvey Murphy. I'm a community organizer. It's a blessing. I just want to give you like a quick story. My first encounter with solitary confinement. I'm gonna just walk you down. My first time on Rikers Island, I got into it with a CO, and the CO let me know that this is our house. So, you know, young kid, I didn't really care about it. You know, I was very disrespectful towards him. So he said, I got something for you. So 2 days later, I get packed up. Next thing you know, I'm going in a dry cell. I don't know if you guys are familiar with a dry cell. I sat in a dry cell for 48 hours. No water. I had to urinate and shit inside a bucket for 48 hours. I got back to my cell after 48 hours. They never found nothing. Somebody had mentioned the PREA, how I got in solitary confinement, how I got into the situation with the correctional officer because I explained to him he wanted me to do jumping jacks while I was being strip searched. So what I did was I wrote a letter and I put it inside the PREA box. And I guess he went inside the PREA box and took it out and said, I got something for you. This is our house. Ain't no snitching going on in our house. So they sent me through the trials and tribulations. I wound up getting box after that. After that, from box, I went to the dry cell. They never found nothing on me. They moved me back to my cell. Honestly, I felt like I was treated like an animal. I felt like my dignity, my as a man I just felt bad at the time. Overall, I beat my charge. I was never convicted. So it's just sad to say that, you know, as a human being, we treat human beings like this. So I don't want DOC to run these new facilities. These monitors, these scanners. I just visited my brother last week. I was touching money, and they scanned my hand, and I couldn't go visit him. I drive from here all the way to Clinton, Dannemora, and I get up there. They give me a hand swab, and I couldn't visit my brother because I was touching money. So money got paraphernalia on it. So I just want to say, man, conditions matter. I just want to say, like, we're talking about human beings. I was almost forgotten. Let's just not forget about human beings. Conditions do matter. I just want to say thank you. I appreciate you guys. It's an honor.
Thank you very much for speaking today. Vidal Guzman.
Hey, how you doing? My name is Vidal Guzman. I'm from Just Leadership USA. First, I really want to say this, Elias and the Department of Correction, this is not about cluttering the water. This is about putting human beings in front and center of this conversation. Separation is still solitary confinement. The name change can be anything else as long as we as society think different about the people who can't do for themselves. It's the most important thing as a society. People right now are in solitary confinement trying to figure stuff out. And their life is in our hands. This is not about advocates cluttering the water. This is about human beings. This is about people who look like us being in solitary confinement. This is not about safety. I'm a person who spent 2.5 years in solitary confinement. You know, I did 7 years incarcerated. I was in the hellhole of the Department of Correction fight club at 16, 17, and 19 till I was 24. I did 7 years. I was in solitary confinement when I was a young person, and we know that a child's mind doesn't fully develop at 25. There's a certain point in society of how we go home and look in the mirror and say, what did we do today to change the world? What exactly is the future for us as New Yorkers? And let's make solitary confinement the hanging fruit. And let's show this country that solitary confinement should never exist. What it does and what's gonna do is keep killing people. If it's not physically, it's mentally. So it's a time right now to stop changing the name of solitary confinement and really start attacking the root issue of what lands a person in there in the first place. One, the Department of Correction does not have the abilities to do the work as they're supposed to. How do they de-escalate violence? They don't know how to do that. What are we doing to exactly fight this? It's time for us as a city to stand up and say it's time, it's over. It's over for solitary confinement. What will we do today and the months coming will shape the image for this country to look at us as the cities that's leading in the criminal justice system, or the city that just cares about what the Department of Correction says and about the so-called clouding water. Advocates are here because we have experienced what it means to be in solitary confinement, and I still feel the impact of solitary confinement. Let's do what we're supposed to do. We are New Yorkers, we are your neighbors, and it's time to do what we're supposed to do, end solitary confinement.
Thank you. Thank you, Mr. Guzman. And I want to thank everyone who has spoken this morning. The public commenters have raised important concerns about the implementation of separation status, and the board will seriously consider them as we work toward a variance with conditions. I also want to acknowledge that the department has provided the board with a proposed rule on body scanning and separation status. As we consider the department's proposal, we will work to put in place a variance with conditions, including data reporting, that will inform our rulemaking. Ultimately, our objective is to develop a rule that both acknowledges the importance of body scanners as a tool to promote safety and also protects critical rights of people in custody and transparency. And now I'm going to ask Michelle to So Mr. Fusco has arrived in the meeting, has been signed up to provide public comment. You may have your 3 minutes.
Good morning, everyone, ladies and gentlemen of the board. Please excuse my tardiness. There's a few situations I had to take care of this morning, and traffic was rough, so I'll make this quick and brief. I'm here this morning to respectfully ask and request for your assistance in helping us lobby with City Council in some resources that we need that concerns our health and safety of our officers. We've been asking for certain criteria of gas masks for personalized ones. I'm sorry. My name is Frederick Fusco. I'm the legislative chairman of the Correction Officers Benevolent Association. For a while now, we've been asking for some resources that may help our members and help the staff of DOC. We're looking for personalized gas masks. In this, some may think that a personalized gas mask will cause maybe more spraying, maybe more use of a chemical agent, but and the fact is that it's not used in that manner. We have pro teams and we have response teams that act on emergency situations. And for example, in maybe the month of February, when there's a lot of sick people, we have a pro team area that we suit up for in case there is an emergency. And in some instances, it's AMKC, which is a big facility. One person may have to use that mask maybe one time a day, but 5 others may use that same exact mask that day. So it's a health and safety concern, and we're trying to individualize the gas mask per person like we do with our safety vests and other equipment. So I'm asking, please, respectfully, for your assistance in helping us lobby with the City Council to try to purchase and get those gas masks for each individual one of our members so they can each have their own. And furthermore, we're looking to better our resources as far as our academy is concerned. I know they had put aside a budget for a brand new academy. I know it's been troublesome trying to find some space, but I believe if we can get this space, we can make the curriculum a little bit more wide-ranged, where we can have better mental health training and better resources come into the academy. Right now, we're currently at Metropolitan. We're still in a mall. We're occupying space in John Jay, and we're no longer occupying that space in John Jay. Listen, with evolution and knowledge and education and the right resources, we can do the job that we need to do. We need a better facility for training. With that being said, also with the different resources, we rely on antiquated systems in the facilities, such as landline phones. You know, we have personnel, we have the detainees that need medical attention sometimes, and sometimes we need an ASTAT. I believe selecting a type of smartphone for the facilities will forthright bring some safety concerns into the facility. But thank you again for your time, and I'm sorry again for the tardiness. Have a nice day.
Thank you. No, that completes public comment on the variance that has been proposed. Michelle is going to provide some information that we've learned regarding the implementation of the scanners and separation status since operations began over the summer.
So a body scanner is a security tool that utilizes a low dose of, excuse me one second. On? Okay, thank you. Okay. I'll start over. A body scanner is a security tool that utilizes a low dose of ionizing radiation to conduct full body scans capable of detecting objects placed on, attached to, or secreted within a person's body. In October 2018, Governor Cuomo signed a law that allowed the department to use body scanners in jails. Body scanners can only be used on people in custody, not staff or visitors. The board joined the department, city council leaders, COBA, and a number of community-based organizations to support passage of the law, citing body scanners as an additional necessary tool to prevent violence in the jails. In supporting the legislation, the board said that the body scanners would only be effective if used alongside the department's other violence prevention initiatives, such as increased programming, additional staff training, further reforms to restrictive housing, and a continued citywide commitment to reducing the jail population. In July 2019, the department began using body scanners on people in custody to identify contraband. If a person scans positive for contraband or refuses a scan, the department places the person into separation status. Body scanners are in operation at 4 facilities. Everyone entering DOC custody must be scanned, and scans can also be used to detect contraband after certain other events. If the department identifies contraband on a body scan, in other words, a positive scan, or a person refuses a body scan, DOC places the person into separation status. The department keeps people in separation status until they receive a negative body scan or post-bail and are released from custody. Separation status involves 24-hour lock-in, except for the offer of a daily shower. Correctional Health Services conducts daily medical rounds on the separation status unit. Do we need to, I guess I'll leave this out about the variance. Okay. Following discussion between the department and Correctional Health Services, the department is mitigating potential health risks of separation status placement by requiring a ratio of 1 correction officer to 1 person in custody and uninterrupted supervision of each person in this status. Board staff has closely monitored the separation status unit since it opened on July 18th. There have been 26 placements into separation status. Each has been documented on the board's website, including date of placement and date of release. The board reviewed placements between July 18th and August 28th. Of the 19 placements, 6, or 32%, resulted from individuals refusing to be scanned, while 13, or 68%, were positive scans. Stays in separation status have been between 1 and 3 days, with 13, or 68%, for only 1 day. 11, or 58% of the 19 placements were young adults, ages 18 to 21. 9, or 47%, had a BRAD age designation, including 1 who was placed twice. The unit does not have air conditioning. However, none of the placements were of heat-sensitive individuals. 10, or 56% of the 18 people placed into separation status were Black, and the other 8, or 44%, were Hispanic. According to the department's variance request, 6 pieces of contraband were recovered from people in separation status between July 15th and August 20. DOC officers and captains who use the body scanner receive training on the use of the scanner and interpretation of images. Rules of the city's Department of Health and Mental Hygiene require the department to post specific signage at all machines in English, Spanish, and any other languages DOC deems appropriate or necessary. In 3 of the facilities, board staff found the signage was not clearly visible to people entering the scanner, and none of the areas had visible signs in Spanish. I would just like to thank the board's monitoring staff, and in particular, its director, Cherie Tripp, and monitoring staff member Dilcio Acosta, who, for his tireless efforts in monitoring the day-to-day operations of the separation unit. And I also want to express many thanks to the research unit's Kate Horton for her excellent and informative analysis of the data that we have gleaned so far from this process.
Dr. Cohn.
I want to thank everyone who spoke this morning. A number of years ago, we didn't have comments before we had to vote on a variance or something. It's quite a important practice that the board has instituted, and really appreciate the effort of those who prepared remarks. There are certain underlying commitments that the board is trying to pursue in its development of rules regarding restrictive housing. And those rules apply to this issue as well. In particular, that the process should be the least restrictive. I want to say that I wrote a letter to Albany in support of this. I lobbied in support of having the scanners available. I think it's a very important technology. I think there are a lot of things we don't know about it, but I personally have supported this and will continue to support that. But two things are critically important, and one is that they be least restrictive. I found the department's variance request disturbing. In the amount of deprivation that was desired, and I also think it is critical as we go forward and review this process that people not languish in these in these places, and that the policies in place assure that won't happen. That is something to be achieved, not yet achieved. Not that people are languishing. We know that currently people are spending 1 to 2 days generally, but this board needs to know that that's not going to happen later on. So, thank you.
Thank you.
Just want to say a few words. And I understand that we will be working with the department to try to come to an agreement as to the variance. I, too, support the scanners in the jail. I mean, there's no doubt it's a tool that they need. But I am concerned that it's overly restrictive and that there is no due process. And there is, whether there's a chance of the false positives that was raised. So I hope we can work out an agreement that includes, access to daily scans if that incarcerated person wants it, to try to prove that they, in fact, don't have a weapon. And the other thing I feel compelled to say, I looked at the way the state, and I personally would like to know much more about how the state handles their special watches when they find the weapons using the body scanners, and what other jurisdictions are doing. But I was particularly troubled that part of the protocol includes that another incarcerated person has to search the waist. That's not what the state does. That's part of the job of an employee. So I would ask the department to look at that. I think that's really degrading, and I don't know whether that incarcerated person won't be able to have a job if that person doesn't want to screen the waist of another incarcerated person. But I certainly think that that should be changed as well. But I'd be very interested to hear what the state does and what other jurisdictions are doing, and to work closely with the department to come up with a variance with conditions that ensure the safety of everybody there, as well as dignity and due process for the incarcerated person. Thank you.
Thank you. And with that, I want to confirm for the record that the department has withdrawn its request for a variance. And
yes, this is confirmed.
Thank you. And we look forward to working with you moving forward. With that, we'll move on to the next item on the agenda this morning, which is an update on the implementation of the Board of Corrections injury reporting rules. In January of 2019, the board published a report finding that in 2017, there was an 81% discrepancy between the number of serious injuries diagnosed by CHS and the number of serious injuries reported by DOC. We also found systemic problems in investigating, monitoring, and preventing injuries in the jails. At our meeting in July, the board approved new rules which address deficiencies identified in the serious injury report by requiring DOC and CHS to comply with surveillance and reporting requirement. Those rules took effect on August 21st, 2019. The board has requested that DOC and CHS provide an update on the implementation of the new rules. Good morning.
Good morning. I'm Ben Farber, Correctional Health Services. CHS has been reporting serious injuries to the department for many years for the purposes of supporting their investigations into serious incidents. And on January 1st of this year, CHS implemented a new definition of serious injuries to support more consistent and less subjective classification. And this is represented in the data that we have been sending directly to the board. CHS began a new coordinated electronic injury reporting protocol with the department on August 14th, and will begin reporting to the board using the table structure outlined in the board rules beginning in October. I'll turn it over to my colleague, Ms. Wax, at the department.
Good morning. I'm Dana Wax, Deputy Chief of Staff, and I'm joined this morning by Chief of Department Hazel Jennings. I appreciate this opportunity to update you on the department's efforts to address the board's concerns regarding the tracking and investigation of serious injuries. The department takes all injuries seriously and is committed to maintaining a safe environment for everyone who lives and works in our facilities. In the months following the January board meeting, the department worked closely with CHS to revise the injury to inmate form and develop a shared protocol for the reporting and capturing of serious injuries. The newly revised form includes 9 checkboxes for the 9 serious injury categories as determined by CHS. It also includes a box for less serious injuries that do not fall into these categories, as well as a box practitioners can mark as pending, so as to convey to DOC that the individual may have a serious injury, but his disposition requires further testing. The updated form and revised directive were rolled out in August, following a review and input from the Nunez Monitor. The department has worked to implement all of the board's recommendations. As requested by the board, the department will begin reporting jointly with CHS on serious injuries. The first of such reports will be provided in October of this year. The department will also begin sharing copies of all injury to inmate forms that describe a serious injury with the board on the 15th of the month. Further, the department has evaluated its process for reviews, developed an electronic tracking system to better review injury to inmate investigations, and taken steps to review and reduce the incidence of serious injuries at AMKC. Once again, I thank the board for the opportunity to discuss the department's efforts to improve serious injury reporting and investigation, and we are happy to answer any questions you have.
Dr. Cohn?
Sure. So we have a protocol with the department, and we're working through all of the kinks and electronic transmission as requested in the rules. And once that's finalized, I believe so.
What percentage of your clinicians and site medical directors have been trained on the new injury reporting policies and procedures, and what's your timeline for completing that training?
Certainly. I don't have the exact number, though I'm happy to get back to you. Just generally for our training, our on-site medical directors through regular in-servicing and morning huddles are providing that information and training.
Are there any further questions? Okay, thank you very much for the update, and we'll look forward to working with you moving forward. The next item on our agenda is ACS's update on services for young mothers with their children.
Thank you. In July 2019, the board approved a variance that allows the department to house young people at Horizon, which does not have child care or a nursery program for those who give birth while in custody. The variance includes a condition that the city shall present more specific information regarding the provision of contract services for young mothers with their children, including an update on these contracts at the July public meeting and a full report at a fall board meeting. The July update is on the board's website, and we have asked ACS to present its full report today. There have been 3 pregnant youth in custody since Horizon opened, and each person was released significantly in advance of her due date. Go ahead.
Good morning.
Good morning.
My name is Tim Roach. I'm the Senior Policy Advisor in the Division of Youth and Family Justice at the Administration for Children's Services. I appreciate the opportunity to be here today to provide you with more information about how ACS and DOC work with pregnant and parenting youth at the Horizon Juvenile Center. First, I want to thank the board for its support and guidance in our efforts to successfully implement Raise the Age. I'm grateful to have this opportunity to appear before you just weeks before full implementation of Raise the Age. It has been a challenging, rewarding, and successful first year. We can all be proud of the fact that for 344 days, there have been no 16 or 17-year-olds on Rikers Island, and take comfort in knowing there never will be again. We are pleased to be back here to share more details on how we have been planning for and with the pregnant young women who have been detained at Horizon during the past 11 months. As you know, for the past 11 months, pursuant to state raise the age legislation, 16 and 17-year-old youth previously housed on Rikers Island and 17-year-olds arrested and detained since October 1st of 2018 have been housed at the city's specialized juvenile detention facility, Horizon. We refer to these youth as pre-RTA youth. At Horizon, as required by state law, ACS and DOC have been collaborating to jointly operate a facility that provides for the safety, security, and well-being of youth in a developmentally appropriate setting and manner. Prior to the Raise the Age effective date, BOC granted several limited variances, which were most recently renewed on July 8th of 2019. These variances have enabled ACS and DOC to provide developmentally appropriate care, supervision, and services for pre-RTA youth within the Horizon facility. In June, when ACS and DOC requested the 6-month extensions to the limited variances, BOC asked ACS to return in September to provide a more detailed update regarding the 6-month limited variance, allowing DOC to house pre-RTA youth in a facility that does not have necessary childcare and a nursery program for youth who give birth while in custody. This variance contains several conditions, including that DOC notify the board in writing within 3 business days of each pregnant youth admitted to Horizon, and that DOC ensure agencies maintain appropriate placements outside the detention facility where youth could be placed with their babies. ACS, DOC, and CHS have a protocol in place to alert BOC of the admission of a pregnant youth within 3 business days while preserving the youth's right to confidentiality. Since October of 2018, there have been 20 female youth admitted at Horizon, including 4 young women who transferred from Rikers. We have had 3 confirmed pregnant young women admitted in that time period, all of whom were discharged relatively quickly and long before their due dates. In all cases, the young women received appropriate prenatal and medical care while at Horizon, and those who were eligible were referred to the nurse-family partnership. As previously discussed, youth at Horizon are able to access a portfolio of portable parenting services designed to afford a wraparound model of support to pregnant youth and all young mothers and fathers detained at the facility, and then follow the youth back to the community and other settings when he or she is released from Horizon. These services include nurse-family partnership, parent coaching, a fatherhood program, sexuality education, and consultation. ACS case management staff also arrange for parent-child visits at Horizon for parenting youth. In addition to notifying BOC and providing expert prenatal care and wraparound services to pregnant young women at Horizon, ACS conducts individualized assessments and works with young women to make plans for their baby. This individualized assessment is similar to assessments DOC makes for young mothers at Rikers when determining whether it is safe for the baby to be with the mother at the Rikers nursery. In June, BOC asked ACS to formalize the process for these individualized assessments. We are pleased to report that by working with our partners at CHS and DOC, we have developed and disseminated a thoughtful process for working closely with any pregnant young woman at Horizon and with her support network. The individualized assessments and case planning we do is the same if a young woman enters Horizon later in her pregnancy, with the exception, of course, that the ACS case management team will expedite the scheduling of the planning meeting. I will now describe the key elements of the protocol for individualized assessment and care planning for pregnant youth. When a young woman enters Horizon and is pregnant, ACS and DOC will notify BOC within 3 business days of the entry, or of learning she is pregnant, whichever is sooner. All pregnant youth will receive prenatal care immediately, as well as postpartum care. Such care must be consistent with the New York State Department of Health Prenatal Care Assistance Program regulations. Immediately following the pregnancy confirmation, a medical provider shall meet with the pregnant youth to determine whether the youth would like any information in order to be adequately educated and informed about all pregnancy options. Discussion and counseling regarding all available options must be provided as soon as possible, but no more than 72 hours after pregnancy confirmation and ongoing thereafter as needed throughout the pregnancy. For pregnant youth who are considering termination, CHS will provide non-judgmental, unbiased information about abortion and access to services and/or make alternative referrals to providers who offer these services to enable youth to make informed decisions about their pregnancies. Following termination of a pregnancy, the medical team will follow closely and provide any necessary post-termination medical care. Throughout the youth's experience related to pregnancy, regardless of whether the youth decides to maintain, terminate, or loses the pregnancy due to natural causes, ACS will offer youth trauma-informed counseling and support by a licensed mental health or social work practitioner. If the young woman decides she would like to maintain the pregnancy, the assigned ACS case manager working at Horizon will speak with both health services and the child's criminal attorney to assess the likelihood that the young woman will remain at Horizon when she is due to deliver the baby. This will include looking at the youth's age in relation to her 18th birthday, her due date, and the legal assessment as to how long the youth is likely to be at Horizon. The ACS case manager will convene a planning meeting within 2 weeks of entry if the young woman is less than 20 weeks pregnant, and sooner, as soon as possible if the young woman is further along in her pregnancy. The case manager will speak to the young woman about who she would like to have at the meeting. This could include the young woman's parents or other family members, the father of the baby, and anyone else the youth would like to invite. The conference will also include the ACS case manager, of course the young woman, a health services representative, and the ACS executive director of Juvenile Justice Behavioral Health Services, or their designee. This meeting will focus on developing a plan for the baby. It will include hearing what the young woman's wishes are with regard to where she would like the baby to reside after he or she is born. For instance, does she want the baby to be placed with the baby's father, or perhaps her parents, or another kinship resource, or with her in a mother-child facility, if that is possible. If the young woman develops a plan for the baby to be in the care of a resource, this can be arranged by the young woman and the resource without child welfare involvement. If the young woman is unable to identify a resource and would like to voluntarily place her child into foster care, the ACS case manager will contact the ACS Division of Child Protection and conduct a child safety conference to discuss this arrangement. If the young woman would like to be placed with her baby, and it is possible that the young woman will still be detained at Horizon when she gives birth, the following steps will be taken. The ACS case manager will make an assessment of the safety of the baby being in the care of the mother in the same way DOC currently does for women at Rikers seeking to use the nursery. If the ACS case manager's assessment is that the baby would be safe with the young mother, the case manager will speak to the young woman about working with her criminal attorney to convince the court to either release the young woman to her family, perhaps with services, or to release the young woman to a foster care mother-child program, possibly through a voluntary placement agreement signed by the young woman's parents. If the judge decides to release the young woman on the condition that a voluntary placement agreement is signed by the young woman's parents, the ACS case manager will contact the ACS Division of Child Protection to arrange for the voluntary placement of the young woman. In conclusion, I would like to thank the Board of Correction for its commitment and its passion for the youth at Horizon, and in particular for any pregnant or parenting youth in our care. I'll take your questions.
Thank you. Brian?
I just want to thank you so much. I really appreciate it. It was so thoughtful, so detailed, very comprehensive. It's what I expected that you all would do, and I think it's really good that my colleagues and I could hear what the actual plan is. So thank you so much, and congratulations to ACS and DOC for the implementation of Raise the Age thus far. Thanks.
Thanks very much. I would just like to say that it really was a partnership effort. DOC and CHS were right at the table with us, and we issued both the protocol around the notification and the procedures that I just described in a written format with the letterheads of all three agencies atop the document, and it was widely distributed.
Thank you very much for the update, and we look forward to hearing about the continued rollout of Raise the Age.
Thanks very much.
Should I just go ahead? Okay. Based on board member interest and concern about staff wellness, we've asked the department to present today on this important issue. Correction officers face significant and daily occupational stressors and trauma as a result of their very difficult jobs. If not properly managed, stress increases the risk for correctional officers to suffer from heart disease, hypertension, diabetes, and other physical illness. Stress also negatively impacts mental health. The research in this area shows that the effects of stress extend to and impact the jail environment through reduced work performance, absenteeism, employee turnover, and replacement costs for new employees. Stress and its consequences also negatively impact safety inside jails. We commend the department for addressing these issues and investing in this area, and I know the board looks forward to hearing more about this work. Would the department please share an update on its staff wellness initiative?
Sure. Hello. My name is Justin Von Boydash. I'm the Executive Director of Chaplaincy and Staff Wellness, and it's a pleasure to be able to be here to share everything that we've done over the past year and a half on staff wellness. And what I would like to start with is, beginning in March 2018, Commissioner Brand created the Division of Chaplaincy and Staff Wellness dedicated to be able to provide these services for our staff. And there's a presentation behind you, so yeah. If you want to take a moment. Whoop. All right. Yeah. Thank you. Okay. So the New York City Department of Correction Division of Chaplaincy and Staff Wellness, I'm going to go ahead and read a little bit while you do that, is tasked along with ensuring high level of spiritual care for all in our system, specifically with developing and implementing wellness mechanisms for staff in order to expand supportive services for all staff, both uniformed and non-uniformed, for New York City Department of Correction. And to this end, what we ended up doing was repurposing the Visits House from GMDC after it was decommissioned, and a wellness center was built in that space. The space was renovated, and it was renovated to include a staff fitness center. So there's an area for staff to be able to focus on physical wellness. On the second floor, there's a multi-faith chapel and a mosque space, both dedicated for staff to be able to engage in spiritual reflection. There we go. Great, thank you. As well as treatment rooms, program areas, and counseling areas for group therapy. So this could be anything from staff who are caring for loved ones at home, or it could be people who are going through their own health concerns, as well as more targeted counseling for staff who are having difficult times. We also provide organized trauma debriefing and critical incident response and wellness programming for our staff. and have expanded training modalities to help staff cope with stress. And largely, the entire kind of function of all of this is to be able to promote a culture of self-care throughout the agency.
And so what this ends up looking like actually is
usually on a one-on-one basis, being able to ask staff how do you care for yourself? You know, what makes you feel strong? What makes you feel resilient? As we'll see later in the presentation, the level of factors that really contribute to burnout, to anxiety, to depression, et cetera, have been relatively well studied in correction across the board. There's not a tremendous amount of information, but across the board, it is pretty concerning, the impact that a career in corrections can have. It doesn't always have to have such a negative impact. I'm going to give this a shot. Next slide. So the definition of wellness that we're working from has been sourced from the National Wellness Institute. The term wellness has been applied in many ways, although there might be different views on what wellness encompasses. Discussion amongst leaders in health and wellness have isolated a few general ways through which wellness can be understood. So first of all, wellness is a conscious, self-directed, and evolving process of achieving full potential. Wellness is a multidimensional and holistic, encompassing lifestyle with mental and spiritual well-being, as well as relationship to the environment. Wellness is positive and affirming. So in short, wellness is an active process through which people become aware of and make choices toward a more successful existence. I know that in this arena, we're generally talking about the details of what happens in our facilities. Our work in this regard is focused on the individuals who work for New York State Department of Correction. And while these also might seem abstract, as human beings, we are abstract, complicated people. So whether or not you're just starting off as a correction officer or you're nearing the end of your career, you're a human being that needs to be affirmed, that needs to be able to find meaning, that needs to be able to be cared for. And this is really the primary action that we're engaged in with wellness. Typically, wellness is looked at from 8 different lenses, or there are 8 dimensions of wellness. The first being emotional. And this focuses on coping effectively with life and creating satisfying relationships. Environmental wellness, occupying pleasant, stimulating environments that support well-being, which is difficult now and in the future as we build these new facilities, is something that we're looking at. Financial wellness, satisfaction with current and future financial situations. This might seem, at first glance, a little trivial, but if you have a lot of financial problems, every moment is stressful. Every paycheck you receive might not be enough. And all of this just puts a tremendous toll on staff. Intellectual wellness, recognizing creative abilities and finding ways to expand knowledge and skills. In the kind of popular, common narrative you find in a lot of newspapers, correction officers are seen as mean people. And intellectual wellness really is about understanding that people are deep, multifaceted individuals, and recognizing their creativity is an important way of addressing their humanity. Occupational wellness focuses on personal satisfaction and enrichment from one's work. Physical wellness, of course, recognizing the need for physical activity, healthy foods, and sleep, and all of these have been very well studied in relationship to their impact on stress. Social wellness, developing a sense of connection, belonging, and a well-developed support system. And spiritual wellness, which is expanding a sense of purpose and meaning in life, which we should all hopefully have some relationship to. The key benefits in this particular context involve a variety of ways of being able to relate not only to the agency, but to one's peers, and then to a larger sense of meaning within one's experience of life. we're trying to support people so that they can feel motivated and empowered to connect to feeling a sense of purpose in their work. And when we're able to do this, this allows for a sense of personal context through allowing staff to bring their full sense of self and purpose to their work, which creates a sense of agency through allowing staff to develop a voice and understand their impact, whether it be on a housing area, whether it be in the particular jail facility they work, whether it be in the department at large. And this lends itself to a sense of belonging, the creation of a sense of community or family, as well as a sense of respect. And we want to let know staff that they're valued. And then this ultimately lends itself to a sense of security, which is not security in the sense that the lovely uniform staff take care of, but this is a sense that we can be safe in offering our views, that we can express ourselves and be heard. And this actually directly relates to how people rise in the ranks, right, where our leaders come from. Our leaders come from within the agency typically. And so if people can understand that when they're motivated, they have a sense of agency, they're respected, they have a sense of belonging, and a sense of security to be themselves, it's more likely that we're going to have leaders that can rise through the ranks and be the kind of leaders that we want. Staff wellness is part of a larger promotion of culture change at New York City Department of Correction. And after assessing wellness needs and the well-being of our staff, we determined that we need to continue to work towards mitigating the long-term effects of trauma, stress, long hours, and the impact that they've had, as well as programming that can play an important role in increasing staff resilience and coping skills. This is just one of the ways that we're working to reduce violence in our facilities. This is predicated on the fact that when you have staff that are less stressed out, less tense, less perhaps on the precipice of being burned out, or if you have a sick family member at home and you come to work holding all of that, that you're going to be able to react more appropriately, right, and not necessarily snap. Anybody who's in this hall who's a parent, and when you're a parent and you're tired and you're carrying work, stresses and responsibilities, makes it a little bit harder to be the kind of effective parent you want. That's a very similar principle in relationship to our staff. The Wellness Center is open 24 hours a day, Monday through Friday, and then from 9 a.m. to 5 p.m. on Saturday, and then 1 p.m. to 9 p.m. on Sunday. Part of our longer-term area of focus is PTSD and critical incident trauma debriefing. And this has been informed by actually the first pull quote is from a study that came out in May or June of 2018 that suggests that prison employees, so this study occurred in Washington State, but basically follows the kind of trend that you find across the country. Prison employees have a PTSD rate equivalent to Iraq and Afghanistan war veterans and higher than police officers, suggesting the importance of developing programs for promoting resilience to stress, incorporating knowledge gained on risk and protective factors. And similarly, in a study published by Desert Waters, done in 2012, of a survey prison employees, 27% were found to be suffering from PTSD and higher rates of critical incident exposure involving violence, injury, or death. They were associated with a greater response for developing PTSD. Now, these facts they don't necessarily exist in isolation. These are things that we're really looking at when it comes to what happens in our jails 24 hours a day, 7 days a week. Part of my wellness staff responds to staff in the jails when they find themselves assaulted or in difficult situations, in the local emergency rooms, and go to their homes in order to be able to assess and connect them with the appropriate sources so that we're able to help reduce the longer term effects of PTSD. Some of the longer term effects of PTSD can be measured here. This was also from a study published by desert waters. And it charts the relationship between depression and PTSD and their comorbidity when they arise at the same time. And so if you see the first set of vertical bars on the left, that's the impact of depression, both on the blue is exercise per week, the red is social activity per week, and the green is spiritual activity. But PTSD, you can see in the next set of bars, it's a little bit elevated except for spiritual activity. When there's a comorbidity of both PTSD and depression, with the exception of exercise, everything else kind of drops, right? And there is actually a close correlation between PTSD and depression. And it's not fully understood, especially within corrections and these kind of more traumatic or occupations where there can be the experience of trauma, which creates the conditions for the other. So this is just included in here to be able to show the impact of not caring for staff. But this is actually a real important thing that needs to be addressed. So as far as staff wellness and stress goes, the negative effects of stress, and this has been studied, include increased contentious relationships, so that could be at work, that could be at home, decreased work performance, distraction on the job, burnout, depersonalization, emotional exhaustion, decreased commitment to work, and in rare cases, increased perception of danger. And this is common with PTSD as well, that you'll have this sense of just constantly not being safe. So you could be walking through our jails as a uniformed member of staff and just constantly be worried, constantly afraid. And this, of course, isn't something you leave at work. This is something that you take with you when you cross the bridge, when you go back home, and when you perform all the functions in your personal life that are important. And therefore, we're looking at ways to develop solutions. Ultimately, knowledge is power. So we're trying to increase awareness of how stress affects all of us, and to define coping strategies that work for all of us, and to work on developing emotional literacy, which means really understanding and having the capability of knowing when I'm triggered, when I'm stressed out, when I'm tired, when all of these things are creating or impacting the decision-making processes as they arise. And so part of this involves teaching people about self-care. So when you feel stressed, what can you do for yourself for short-term benefit? So teaching people how to take a break, the impact of exercise, meditation, yoga, or martial arts, if that's important for you, talking it out, and peer support. And actually, peer support is, in my experience at DOC and in other uniform agencies, one of the kind of like magical sweet spots where typically uniform members of staff will trust another uniform member of staff first. And that person that they speak with, that peer, holds a tremendous amount of power in helping to first get the concerned member of staff to greater help, right? And to hear them because they understand them. So peer support is huge, and talking it out has significant impact in terms of positive resolution of some of these problems. Music, for some people, is a powerful way of dealing with stress and anxiety. Diet is huge because diet has an impact on physical health, and when we have high blood pressure or other problems with our physical body, that affects us in other ways. And then, of course, making use of therapy, physicians' visits, et cetera. These are some pictures of our fitness centers, some staff engaged in weight training and aerobic exercise. Our fitness center, we have a fitness center as well as a juice bar. And it represents a commitment to ensuring that DOC staff have access to means to address physical fitness as a form of self-care. From April 9th to December 4th, we've logged in 4,098 visits to the Wellness Center from our staff. And so that's not just uniform staff, and it's actually not even just only DOC staff. We have CHS staff come in, non-uniform staff come in. I typically start my tour early in the day. I'm there around 5:30 or 6 in the morning, and there are already people working out in the gym. And then, so we have a multi-faith chapel and a mosque. So we opened on December 8th of this year, which was a little bit before Ramadan. April 8th, which is a little bit before Ramadan. And so we were able to hold Ramadan observance for staff for the first time in the mosque space there. Since we opened, we've had 227 visits to the mosque. We currently hold mindfulness trainings in the multi-faith chapel on Mondays, Wednesdays, and Fridays. And sorry, this slide's a little old. We are in the process of unveiling expanded religious services for staff as a way of aiding and supporting spiritual wellness. So, and actually on Fridays, it's great. If you're there around 1 o'clock when Jummah prayers happen, but there's a steady crew of dedicated staff who come in every week to be able to make use of that. And we also have a reading room and are in the process of accepting donations from headquarters and any staff. And then also a business center, so a place for people to be able to come and take care of personal things they might need. And so the solutions. Part of our solutions are increased clinical support and social wellness. We've hired 2 additional social workers and 2 psychologists to support staff and develop preventative services and programs. Thus, we're moving away from reliance on an emergency response model, so where we're constantly putting out fires. I think next week is my 3-year anniversary with DOC, and when I first came in, I came into the unit, the care unit, which provided a lot of these kind of more emergency services for staff. And we were going out sometimes 6 times a day to hospitals. And moving away from an emergency response model has been huge because it allows there to be this capability to educate and to be able to help train staff to be able to better understand these longer-term issues, PTSD, depression, get increased help around substance abuse, as well as suicide prevention. I haven't been at DOC. I've been here since this time, 2016. We have not had any suicides, and I hope that we, don't. We take very seriously the connection between noticing when a problem arises and comes to our attention, to addressing it, and to following up to make sure that not only is the person being seen, but the kind of care that they're receiving is appropriate, but then also that the follow-up is real, is tangible, and also appropriate. Since April, we've had 365 visits to our wellness staff. So that includes peer counselors, our psychologists, our social workers, and it ranges from everything from child care issues, you lose your babysitter, you can't change your tour easily, so helping with that, to more serious mental health support. And we're also, we've added an additional chaplain for staff to aid in spiritual support and meaning making. And in June, we launched support groups for staff who are facing cancer, who are caregivers at home, LGBTQ support, and victims of domestic violence. And we've partnered with the mayor's office to end gender-based violence in that, and that's been very helpful, as well as bereavement support. And so these are just a beginning of some of the things that we've started to offer, and part of this is very organic. We look at the data as it comes in, we look at the trends as they arise, and assess from there around what programs will be created. And on Saturday, last Saturday, we unveiled this wonderful 9/11 memorial. In the Wellness Center, we're working on creating a space where we can also honor our staff who contributed time, energy, sacrificed emotional energy, et cetera, to the recovery and rescue operations at Ground Zero. So this is just a beginning of our work. As we move forward to our goals, it's important to remember that wellness impacts the overall health of organizations, not just DOC, mayor's office, hospitals, corporate America, et cetera. Wellness can also be a catalyst for creating outcomes that otherwise would be hard to develop without the investment of care and compassion in our staff. And so part of this is, some culture change can be changed through policy. A lot of culture change can be changed by modeling how we are in relationship to one another, and that's what we're working on. Questions?
Thank you. Thank you very much for the presentation on this important initiative. The data that you presented on the impact of the work on staff and the numbers that you presented regarding preliminary uptake of the services that you're offering speak very powerfully to the need for this initiative to continue and grow. I guess the question that I have is, what feedback have you gotten from staff regarding the services to date? And how are you, on an ongoing basis, in terms of planning to move forward and to grow and strengthen the initiative, what is your system for assessing impact?
Sure. Yeah, no, thank you. So there are a couple different kinds of feedback. The first kind is I'll run into staff in our jails or a hospital or even someone in their home, and they'll tell me, I've worked here 19 years, and there's never been anything like this. This is amazing. And they'll say, my only regret is it didn't happen back when I was new to the department. Typically, most people are more than thrilled about it, and then also everybody can offer that constructive advice or constructive criticism. I instituted a survey, just an informal survey amongst people who come to visit the Wellness Center that asked about the frequency of use, what they used, and then had areas to write in, what do you want to see? And so there was, there was stuff about having personal trainers. There were suggestions around more spiritual programming, and all of these things are being taken into consideration around developing, future programs.
I would just like to add that as we reconstruct and modernize our recruit curriculum, we will be incorporating visits to the Health and Wellness Center from day one when employees enter the department. Also for non-uniform staff as well, their indoctrination into the agency will incorporate being there as part of their training. So when we model how we treat our staff, we believe that will translate into our staff treating others better. And so it's a part of the culture change that we will continue as we move forward. So thank you for that question.
Thank you. Other questions?
I think the commissioner kind of answered my question. One of my questions, can you hear me?
Yeah.
Can you hear me now? Okay, let me get that one.
It's wired. It's on.
It's on? I actually visited the center. So how long have you been operational at this point?
Since April 8th.
Yeah, I think it's a magnificent facility. I couldn't believe that it was a jail at one point. It was totally transformed. But I do have a couple of questions. So it sounds like as you hire people, you're going to promote that you have this wellness center that people can avail themselves of. And how are you promoting it to existing staff currently?
Yeah, so that's a good question. Primarily through our DCPI, our Division of Public Information,
Okay.
which they're responsible for, amongst other things, publicizing and sharing information across the department. So within the jails, there are also email blasts. And then my staff tours the facilities. They try and get out to every facility on a weekly basis. And so you'll find somebody from, Manhattan Courts, right, who doesn't necessarily come to the island much. And they'll end up telling them about it. The big thing, of course, organizationally is getting people from the borough commands to be able to come. But it's a work in progress, but it is on our radar, and it's something that we take seriously.
Right. You're a chaplain, and you do have a cadre of chaplains that work throughout the.
That's correct.
Right. And the psychologists and social workers, they're licensed people. They work for corrections, or
they work for corrections.
Okay.
That's correct.
So then the question that I would have is, how do you handle confidentiality within the correctional system when people come to you? Because you have to develop trust and a rapport.
Right.
I happen to be a clinician, so
Sure,
that's
no,
why
of
I'm
course, of course. So everything that arises in our, in the wellness center or with our clinical staff, so even if they're touring or, something like that, and they meet with staff, everything that is told to us is held confidentially. Now, of course, if somebody expresses suicidality or the intent to harm,
Right.
then we are mandated to report that. But we hold that. Not only do we hold that and take that very seriously, this is somewhat of a way in which we are assessed by staff. So if somebody comes and they have a problem of some kind, and they find out that it gets out, our own credibility is shot,
Right.
and,
Okay.
and the work that we do is for nothing.
Right. Well, I got to say, I think it's a phenomenal idea, and I was really impressed by the facility. I did meet some people that were working there. I think you were just getting started, so I'm glad that that you've grown it and that it seems to be making. I think it will make a difference for the staff there.
Thank you.
Congratulations.
Dr. Cohn?
Yeah, thank you very much. I was impressed by the numbers of people who are coming, and I anticipate that expanding. So just to ask so there are going to be 4 jails, and none of them are going to be on Rikers Island. So what are you in the process in terms of program planning and space planning to get access for your
Absolutely.
for your
I've been
clients,
included in the meetings about the borough-based jails, and staff wellness and staff resources have been a big part of those discussions.
We have some physical space for a gym in each facility, for example, or?
At this point, we're working out those details, so we're not at liberty to talk about those kinds of details at this point in time. It's
I
still
understand
to be
that,
developed.
Heidi, which is exactly why I asked the question. I think it's really important that you start getting your
I could say
in on these issues of
We need a ULURP vote first, so I think we need to first get past that hurdle before we have discussions like this.
But I will say that the interest in staff wellness and the passion around it is shared by many in the department. So I'm sure it will show up in some way.
Great. Thank you.
I have a question. If I'm an officer in OBCC, how do I get to GM? Do we have shuttles that are bringing people to the wellness center?
So you can take the buses. So it goes right along the bus route.
But there's several routes. Well, that's my office. So I don't know if it's changed, but if I'm in OBCC, maybe Road 5 do I have to go all the way back to the control center to take another bus to go back to the wellness center?
At present, yes. We are looking into developing a shuttle.
Thank you very much.
Thank you.
Our next and final agenda item prior to public comment is voting in the jails. Pretrial detainees and those serving time for misdemeanors in the city's jails are eligible to vote. In recent years, voter enfranchisement has become a national issue as well as a local issue, with the City Council passing legislation in 2016 to promote absentee voting among people in custody. Mayor de Blasio launching an initiative in 2018 to increase civic engagement in the jails, and Governor Cuomo issuing an executive order in 2018 to restore voting rights to approximately 36,000 formerly incarcerated people on parole. In June 2019, the Jails Action Coalition submitted a written request to the board that it add jail voting to a public meeting agenda. We applaud the department's recent work to decrease barriers to voting while in jail, and we look forward to hearing more about these efforts today. In addition, we look to and are inspired by our friends in Illinois, who last month passed legislation which expands voter access and education efforts in jails throughout the state, most notably making Cook County the first jail in the country to become an official polling place with voting machines. The jail's polling place will operate similarly to an early voting site, where all ballot styles will be available for any eligible voter, regardless of the person's home address. It will also allow people in custody to both register and vote on the same day. Now required by law, Cook County Jail had in-person voting for the first time in November 2018. People in custody cast 760 ballots there. The board encourages the city to explore the possibility of in-person voting in the city's jails. We also thank legal associate Navi Baines for her excellent research about voting in Cook County and other jurisdictions. And we now ask the department to update the board on its very impressive work in this area.
Good morning. My name is Stephen Kaiser. I'm the Executive Director of Policy and Intergov Affairs at the department. Good morning, board members. Good morning, Michelle. Thank you for having me to discuss this very important work. Before I get into the details of the effort that the department has engaged in, I think it's important to contextualize the importance of voting. Voting is not only critical to the maintenance of a high-functioning and healthy democracy, but it is also a very literal way that people have a voice, not just in federal matters, state matters, or city matters, but also in matters that pertain directly to their communities. So the act of voting, and especially the act of voting for someone that is incarcerated, is a very unique opportunity to supply their voice to a conversation. With that said, in 2018, the department launched its first kind of efforts surrounding increased voter registration, education, and voter assistance for people in custody. Prior to 2018, the department was compliant with local laws by maintaining a stock of voter registration and absentee ballot materials in law libraries and providing people the opportunity to access those forms there. In 2018, the department partnered with the New York City Campaign Finance Board, with the Mayor's Public Engagement Unit, and with a number of stakeholders in the communities and organizations in the communities who lended volunteer support. As part of this work, the department posted over 1,200 informational flyers across the facilities in high-trafficked areas and housing units. These flyers were not just simply get out the vote flyers, but also contain information and updated information with the new legislation the state had passed that Michelle mentioned in her introduction. The department also provided New York City Campaign Finance Board voter registration and civic engagement training to all law library staff, and the Public Engagement Unit additionally provided similar training specifically focused on outreach and kind of human-to-human interaction to DOC program staff who worked in restrictive housing areas. The department partnered with volunteer organizations. The department's program division did a fantastic job coordinating this effort, and we were doing in-unit, volunteer-led voter registration, education, and assistance to people in custody. In addition, the Mayor's Public Engagement Unit worked with staff in the Central Visits House to conduct similar outreach to visitors in the run-up to the 2018 general election. Through this effort, the department submitted 897 completed voter registration forms, 624 of which were for incarcerated individuals and 273 of which were for visitors. Similarly, during this time, we submitted 547 absentee ballot application forms. It should be noted that this effort, through the assistance and the great effort from the volunteers that supported this effort, we were able to do all of this submission and return of ballots by hand. This allowed us to extend deadlines to the hand delivery deadlines that the BOE operates, and also ensures that individuals could get that human-to-human interaction through the process of voting. In 2019, for the primary election that occurred in this past June, we expected slightly less volunteer interest, but to counter that, we printed approximately 45,000 voting information brochures, which are kept in high-trafficked areas as well as law libraries, and are also given to individuals upon discharge. These brochures contain information about registering to vote, with voter assistance, with Board of Election information to assist people with voting once they return to the community and while they're incarcerated during their time at DOC custody. Additionally, in 2019, for the primary election, the department partnered once again with the New York City Campaign Finance Board to provide voter registration training to 22 law library coordinators. And then more critically, in June 2019, the New York City Campaign Finance Board worked with us to create materials specific to DOC that we provided to over 100 program counselors, staff, and even external service providers who we're very grateful to, who are willing to assist in this effort as well. These staff conducted in-unit efforts. There were also some volunteer efforts led in the June primary run-up. But through this effort, we were able to collect 465 voter registration forms and submit those by hand to the Board of Election. I should note in this election, we did not do the facilitation of absentee ballot forms. This is because we were building up the capability through our program staff, which we think the 465 registration serves as pretty solid proof of practice that this is a way to move forward and ensure that people are getting their information and getting forms submitted to the board. As we look forward to the upcoming general election, we're going to build upon the 2019 effort. We're reconducting training to staff, to program staff. The staff training will include absentee ballot assistance, collection, and submission. We're also kind of going through our operational procedures for ensuring that people's forms, once they're returned from the Board of Election, make their way to that individual as expeditiously as possible, and then once again are collected and returned by hand back to the Board of Election. We're also in the process of planning volunteer engagement, and the first effort will be planned for the beginning of next week. And we're partnering once again with the Public Engagement Unit from the Mayor's Office to conduct visitor outreach, and that will actually start near the end of this week. So with that said, I think this work speaks to the department's willingness and engagement on this topic, the belief that this is an important topic worth the investment, the time, and the energy, and we look forward to building upon these efforts in the elections to come. Thank you.
So, you're registering people that are currently in custody. And the plan would be that they would vote via absentee ballots?
If they're still in custody.
If they're still in custody.
If someone were to request an absentee ballot while they're in custody and then leave custody to return to the community, they would still be able to vote at their polling location.
I'm just curious, what address would they use?
So so that's a good question. We actually work very closely with the Board of Election to ensure that we are receiving the forms if the person decides to list us. Individuals can still go through the correspondence system if they wish, but if they want to go through the kind of hand delivery method through our program staff, we provide them the information that they would need to list for the Board of Election to then know to distribute the forms back to
You're
us.
also helping them to register before they leave detention?
Of course, yeah. We're doing this while they're in custody. So for example, for the November 5th election, the registration deadline is October 11th. We're starting our engagement now. So we're starting volunteer efforts next week. We're starting with our program counselors, are going to be doing this in-unit effort across all of the facilities in the coming weeks in the run-up to that election.
Thank you. If Madam Chairwoman, if you could indulge me, I kind of would like to make a quick statement, real quick. As the new member of the board, I think I've learned a lot, and this is my third meeting, actually. I think I've learned a lot, and I kind of recognize that we have many challenges that have to be worked out. And I see that that the Board of Corrections and Department of Corrections, and I call it HHC, I guess they changed it, Correctional Health Services. I mean, there are a lot of stakeholders in this, and I'm committed to making sure that that I can make a contribution to working on all of these critical challenges that we face and we have to resolve. But on the other hand, I also wanted to just make a statement that some of the items that were presented today by corrections, I'm not that familiar with the PREO audit, but it sounds like it was a great thing. I would like to learn a little bit more about it. But also the Wellness Center, the fact that I think I was the one that challenged ACS on having some kind of policy around pregnant women, which I think I caught him flat-footed the last time, but he did a really good job in being able to present a very thoughtful process. So I just wanted to indicate that as well. And I would like to, whichever way that we move forward, to be involved in this issue on scanners. So I just wanted, for the record, to let you know that.
Thank you.
Thank you.
Are there any questions from board members? Thank you very much. We're now at the public comment portion of our agenda, and I will call upon members of the public who have signed up to speak on general topics and remind you that there is an iPad on the stage that indicates your time left. I will let you know when your time has run out, and we will strictly limit you to 3 minutes per speaker. Mark Steyer. Frederick Fusco. Elias Husamuddin. Simone Spierig.
Good morning.
Good morning.
My name is Simone Spierig, and I'm the Jail Services Social Worker at Brooklyn Defender Services. Thank you for the opportunity to speak today. We appreciate the board's attention to the extreme weather conditions this summer and the impact of those conditions on the people we serve. The board's report, released yesterday afternoon, raises critical concerns with DOC's ability to execute an emergency weather plan and highlights important lessons that we urge the board and DOC to consider throughout the year. We ask the board and DOC to act now before hundreds of incarcerated people are forced to suffer needlessly when the winter's extreme temperatures set in. Following the initial heat wave in July, I met with Mr. X, who was then incarcerated at OBCC. Mr. X is heat sensitive, but was housed in an unair-conditioned general population unit. Despite the extreme temperatures, DOC only stationed 2 fans in a dorm area shared by about 50 men. In the heat, Mr. X becomes prone to nosebleeds. As a result, Mr. X spent most of his time laying on his stomach the weekend of the heat wave, terrified that if he fell asleep, he might choke on his own blood. Although he tried to read to pass the time in the extreme heat, his sweat soaked through the pages of his book, so he was unable to read during that time. Mr. X's experience is unacceptable but alarmingly not uncommon. This is just one example of many that highlights the importance of advanced planning and adequate resources. We are deeply troubled over the department's delayed action and call on the staff to be proactive, not reactive, to predictable circumstances like extreme temperatures in the winter. We appreciate the board's efforts to bring awareness to the issue and applaud the thorough report and recommendations issued yesterday. We ask that you continue to demand transparency and hold the department accountable. By conducting ongoing investigations and demanding regular progress reports, you can help ensure that incarcerated people in our city's jails are not left to suffer through extreme weather conditions without any form of relief. Winter is coming, as it does every year, and we have serious concerns about the fate of our clients and other incarcerated people. There are serious, unanswered questions about protocol and potential risks that will arise, not if, but when extreme temperatures occur again. The department must be prepared to ensure people in its custody are safe. The board's report underscores the importance of ensuring there is a concrete plan and mechanisms in place to keep incarcerated people in humane conditions during extreme weather circumstances. Thank you for your time.
Thank you. Jennifer Parrish.
I just have a brief request based on something that I believe you said earlier in the meeting, that the Department of Corrections has petitioned for rulemaking regarding the separation status housing. Well, if that is the case, then we ask that that be released to the public so that we have an opportunity to comment on it.
Right. The department hasn't formally petitioned. They shared with us informally a proposed rule. If they do petition, we will certainly make that public.
Okay. Thank you.
Thank you. Winston Huynh.
again. All right, my usual thing here. I actually wanted to start by thanking the Commissioner and Brenda for their testimony last week at the City Council meeting. I got up there to testify like 4 hours after you guys left, and I said, I actually agree with everything you said about why Rikers needs to be closed. What's frustrating for me, though, is I think a lot of what you conveyed in your vision for that to happen is not, I don't see that in the actualities of today. So I rewatched this morning, actually. Commissioner, you mentioned that you were committed to being part of a 21st century approach to criminal justice. But our law libraries still do not have dedicated word processors. We're still using these like Mad Men 1950s era typewriters. And the minimum standards say specifically that they should have dedicated word processors. So I don't know why that's still there if we're talking about 21st century approaches. You also spoke very compassionately, I think, about maintaining close contact with the community of support, having family members and friends be able to visit. But not everyone can actually come to visit, and a lot of the pictures and the communications come in through the mail. And the mail still takes weeks, sometimes months. My record for the longest letter took 39 days. Similarly, the guys who are working for pennies on the dollar, painting these facilities and doing the work to repair them, they try to send money out sometimes to support their families, and that takes up to a month. So I think if we're wanting to maintain those close contacts with their community of support, I don't understand why those issues are still persisting, which again, those are minimum standards things too. Mail should get there within 48 hours. And then you have also spoken a lot about ensuring that all New Yorkers are treated with dignity and respect. Again, I agree, but when a grown man has to beg and plead with a CO to please, when we go down for lunch, for chow, can you stop by and get me some underwear? Without that agency, again, these are things that are supposed to be provided according to the minimum standards, but we have to ask for them. I don't know how much dignity is in that. Our friends from the SCOC left, but the same standards are within their minimums. It's 2 pair instead of 4 pair, but the same thing exists, and they're not being given these things regularly at any rate. So, I mean, you've mentioned it again here, that you said the DOC takes its culture change efforts seriously, and we're not waiting to move into new facilities to begin the support and work. Again, I see that, but I don't see it here. If the DOC consistently has examples of ignoring these types of things, right, things that are minimum standards, we see these examples of it being ignored. I think that will help this culture persist, where I can do something and think, oh, there will be no reprimand for me because these things are being ignored. What makes me think that what's supposed to happen to me is going to be, that could be a CO, that could be an inmate. But having these things persistently ignored, I don't think is going to help change that culture that wants to be changed. That's enough.
Thank you. Mary Lynn Werlwas.
Good afternoon. I was just going to offer a few comments from the Legal Aid Society and thank the board on the HEAT report that was issued yesterday. It was a very cogent and informative report that had a lot of very helpful information. We are disappointed by the department's written, rather tepid response to the operational recommendations that were in the report. We think many of them had great practical importance, and most of the responses were that the department does not intend to implement these changes or was considering them. But even more troubling is the failure of the response to appreciate what was depicted in your HEAT report as a true failure of the facility level leadership. For example, the report says that the facility wardens have the authority to move an individual out of an uninhabitable cell. So why, when the board staff went, were there individuals housed in a cell, such as in the ESH, that was 97.8 degrees without the benefit of fans? The fans cannot cool the interior of these cells. Why, when the board went, did they find individuals in the punitive segregation cells, which are nominally air conditioned, that were 90 degrees? Why didn't the wardens exercise their authority to move individuals out of these cells? And why aren't those questions being asked? this looks not just like a problem of heat management, but a problem of accountability and a perpetuation of this agency's, I must say, culture of incompetence when it comes to implementing some of the even sensible plans that it has. Unfortunately, the response that we saw in the report to, for example, the ESH recommendation was that the department thinks it is, quote, prudent and reasonable to continue doing the same measures that led to a person being housed in a 97.8 degree cell. That's simply unacceptable. The board cannot countenance this view. The board also, we would request, should respond to the department's admission that it is not following the board's standards requiring provision of hot and cold showers in all of the housing areas. This is especially true given that they rely upon cold showers as their means of thermal regulation when there is no air conditioning. In short, the wardens need to take responsibility for knowing who's in their jails, the heat-sensitive people. The report was very damning in this respect. But the board needs to, throughout this year and before the next season, keep addressing these recommendations. Thank you.
Thank you. Ms. V?
Hi, it's Ms. V again. And I just want to let you know that GMDC was actually redone, millions of dollars put into it for the young adults, and then the DOC closed it and kept it for themselves. So that's why the building is so amazing. But my comments is, no forward-moving humanizing actions in the past 5 years have been implemented by DOC without us advocates forcing them to do so. Commissioner Brand likes to come up here and always say what DOC has done and what they're doing. But let's be clear, they're not doing anything positive without us advocates making sure that they get it done. Advocates have a bad name in this room with DOC. Yet over the past 8 years, I have advocated not only for the safety of incarcerated individuals, but also for all staff in DOC facilities. When we speak of safety, we must be clear on what we are allowing by giving passes to bullies with badges. Not everyone who wears a uniform or has a position of power should hold their position. The chaplain mentioned less stress, not snapping, harder to be effective, like in parenting situations, all unacceptable excuses for DOC to hide behind unnecessary uses of force. Let me be clear. DOC is not the parents of the young adults or the adults that they hold in their custody. DOC are paid professionals, such as medical staff, as I was for over 10 years in the ER, or shelters, and any other environment where the exact same populations are encountered. Personally, I've had a client pull a gun on me. On another job, I was held hostage for over 2 hours by a serial rapist, both documented incidents in which my very life was on the line. And I walked away because I utilized my de-escalating trainings, and I hold DOC accountable like I do hold NYPD accountable, and now I hold you Board of Corrections accountable to stop allowing peace officers to hide behind the illusion of safety for the unnecessary uses of force and barbaric, inhumane treatment. And let me just state, while doing Brad H. monitoring last month in AMKC, many people reported to me that their housing units was constantly searched, researched. In fact, the day I was there, one housing unit was searched within 2 hours twice. And officers was laughing about it, and one officer made a comment, so y'all want to keep calling 311? So I would suggest that you look into DOC's data, the reason for the uses of force, and how they are targeting people that are reporting things that are violations. Thank you.
Thank you very much for your testimony. That concludes the public comments portion of our agenda, and that concludes our agenda. So we will adjourn the meeting. Just a reminder that our next meeting is scheduled for October 22nd at 9 a.m. back in this auditorium. Thank you very much, and today's meeting is now adjourned.